Well, good evening, everyone, and welcome to tonight's event, Representing Refugees Today, a panel discussion on legal sector responses to changes in asylum seeker policy and funding. This has been organised by the Andrew and Renata Kaldor Centre for International Refugee Law in collaboration with the Refugee Advice and Casework Service in celebration of Refugee Week. As we begin, we acknowledge the Gadigal people of the Eora Nation, on whose land we meet today, and pay respects to their elders, past and present. We would like to thank Gilbert and Tobin for generously hosting us this evening. This event is being recorded and the video will be posted on the Kaldor Centre website, and we encourage you to tweet about this event as well using the hashtags on the screen, Representing Refugees and Refugee Week. It's my pleasure to introduce Renata Kaldor, who will be making some introductory remarks and introducing our speakers for this evening's event. Renata is well known for her contributions in the field of business, education and community affairs. She is currently a director of ASI Proprietary Limited. She is a board director of the Sydney Children's Hospital Network, a member of Chief Executive Women, and a member of the Advisory Council of Alzheimer's Australia, New South Wales. Renata was previously a trustee of the Sydney Opera House, a Judicial Commissioner of New South Wales, Chair of the New South Wales Women's Advisory Council, and Deputy Chancellor of the University of Sydney. She was an inaugural board member of the Sydney Symphony Orchestra and has also held board positions on the New South Wales State Rail Board, the Sydney Olympic Bid Committee, and the Garvan Medical Research Foundation. She was awarded the Officer of the Order of Australia in 2002 for her many contributions to the community. Renata is a committed advocate for refugees, and it was the generosity of her and her husband Andrew that enabled the establishment of the Kaldor Centre for International Refugee Law. She is also a Refugee Week ambassador, appropriately for this evening's event, and please join me in welcoming her.
Well, I'd like to thank you all for coming today, and as Francis said, I'm an ambassador for this week for the Refugee Council. I thought it might be good for me to talk a little bit about what Refugee Week is all about. Refugee Week is Australia's peak annual activity, and it's all about raising awareness about the issues affecting refugees and to celebrate the contributions made by refugees to Australia. The theme for Refugee Week this year is "With courage, let us all combine." And that's taken from the second verse of the national anthem. And the theme celebrates the courage of refugees. And it's also for celebrating people who speak out against persecution and injustice. And it serves as a call for unity and for positive action, encouraging Australians to improve our nation's welfare for refugees and to acknowledge the skills and the energy that refugees bring to our country. And it takes courage to be a refugee. It's got the courage. Refugees actually need a lot of courage. They need courage to not to deny the identity or the beliefs they face in persecution. They need courage to leave all that is familiar and step into the unknown in search of peace. They need courage to keep going in the face of devastating loss, difficulty and despair. They need courage to begin again, to work hard and to maintain hope in an unfamiliar land. But it also takes courage to speak out against injustice. And in Refugee Week, we acknowledge and celebrate the dedication and the bravery of refugee leaders, advocates, and citizens who draw attention to the violation of human rights, who support people at their time of greatest need, and the challenges that callous indifference to the suffering of others has. So Refugee Week theme encourages Australians to celebrate the best aspects of our nation's welcome of refugees, to frankly acknowledge the unjust treatment of asylum seekers and refugees, and commit to working to ensure that we are better people, we are a better nation. Refugee Week hopes to celebrate the positive contributions to Australian society over the last 70 years of more than 800,000 Australians who once were refugees and who are now our citizens. And the theme that we are celebrating, with courage let us all combine, comes from the second verse of our national anthem, Advance Australia Fair. Now, for those of you who don't know the second verse of Advance Australia Fair, and I have to admit I didn't know it myself until I read it again, the second verse of our national anthem says, "Beneath our radiant Southern Cross, we'll toil with heart and hand to make this Commonwealth of ours renowned of all the lands. For those who come across the seas, we've boundless plains to share. With courage, let us all combine to advance Australia fair." I think we should all remember that during this week, and let's go on with discussing some of the issues that we're here tonight to discuss. Let me introduce our panel. Gemma Hollins is a solicitor and an immigration agent at the Refugee Advice and Caseworker Service, or RACS. RACS is a not-for-profit community legal centre providing free expert immigration legal advice and assistance to asylum seekers and refugees in Australia. Prior to joining RACS, Gemma worked in legal policy and research at the Anti-Slavery Australia. She previously worked with the International Organisation for Migration in East Timor and with the Human Rights Commission. Gemma holds a Bachelor of Law and a Bachelor of Arts from the University of Sydney. Welcome and thank you very much, Gemma. Next we have Michelle Hannon, who is a partner here at Gilbert and Tobin for pro bono services and corporate responsibility. Michelle specialises in discrimination and human rights law. She has conducted several public interest and test cases in these areas and made a successful communications to the United Nations Human Rights Committee alleging human rights breaches by the Australian government. Michelle is on the New South Wales Committee for Justice Connect and was formerly on the board of the National Pro Bono Research Centre. Michelle holds a Master's in Law and a Bachelor of Arts from the University of Sydney. Welcome, Michelle. David Hume is a barrister at 6 Wentworth Shelbourne Chambers and has worked on cases in various areas of public and commercial law, including migration, discrimination and human rights. David is a Fellow of the Gilbert and Tobin Centre of Public Law and has co-authored 2 books with Professor George Williams. David holds a Bachelor of Law and Arts from the University of New South Wales and completed a Master of Law at Harvard University as a Monash Scholar. Thank you all for coming, and thank you all for being here to be part of this discussion. So perhaps if you could come on first, Gemma. Thank you.
Thank you, Renata, for your introduction, and I too acknowledge the Gadigal people of the Eora Nation and pay my respects to their elders past and present. I've worked at RACS now for over 4 years as a lawyer, and I don't think it's an underestimation to say that for almost every single one of those days, asylum seekers and refugees have been in the news. Even when the news was dominated by frivolous stories such as Johnny Depp's dogs, Pistol and Boo, asylum seekers weren't far from our minds, with the dogs being branded illegal aliens. And like everyone, when we hear the sorts of news stories that are coming through every day, at RACS, we get sad, we get angry, we get depressed, but then we get on with the job because there's a lot that we can do right here in Australia. It might not make the news, but there are currently over 30 or around 30,000 asylum seekers who are living here in the community. They are people who haven't yet had a decision on their refugee status. They've come here generally between 1 and 6 years ago, and because there haven't been any protection visa grants in over 3 years by the current federal government, they've been waiting in limbo. And some people have literally been driven crazy by the uncertainty around their future and over such a prolonged period of time. Since the last federal election, the government has been trying to implement its policy that no person who arrived by boat should be granted a permanent visa. And that's been the main reason for a lot of this delay. But after numerous failed attempts to implement that policy in December 2014, they finally succeeded. By doing a deal with the crossbenchers, the government was able to pass a law that contained several significant changes to refugee law in Australia. I don't have time tonight to talk about all the significant changes that have happened, but I'm going to just talk about 3 of the most significant ones that have one of the greatest impacts on our clients and our work. And I'll talk about the changes and what sort of work RACS is doing to respond to these changes. The first change I'll talk about is the creation of temporary protection visas. The second is the new fast-track process for assessing people's refugee claims. And the third is the release of children from detention on Christmas Island. So the first change is the creation of temporary protection visas, and that actually involves the creation of 2 new classes of visas, temporary protection visas and safe haven enterprise visas. Both of these visas are temporary visas that are granted to people who've arrived by boat without a visa or came by plane also without a visa. The temporary protection visa is a 3-year visa that can be renewed at the end of every 3 years if the person is assessed as still needing Australia's protection. If you have a temporary protection visa, you can never apply for a permanent visa of any kind after that, and you can never apply for Australian citizenship. But perhaps most cruelly, you can also never apply to bring your family members to Australia, and you cannot leave Australia to visit family members, for example, without permission of the Minister for Immigration, which is at the Minister's complete discretion. Safe haven enterprise visas are similar, but they're a 5-year visa, and they have the same conditions as temporary protection visas, except for the fact that they provide a possible pathway for permanency. So that pathway is that if a person for 3.5 years out of the 5 years works or studies in a regional area, then they might have an option of some other type of permanent visa. And the concept is a good one, but the reality is that it's unlikely to benefit more than a fraction of refugees, and particularly not benefit the most vulnerable refugees, because the only visas that people can apply for at the end of this time are skilled or family stream visas, not permanent protection visas. So that means that refugees who happen to have married an Australian permanent resident or citizen might be able to apply for a permanent visa, but people who already have partners and children overseas won't have that option. And for people who want to apply for a skilled visa, they need extraordinarily high levels of qualifications and English. So for most clients of ours, that's not going to be an opportunity. That's not going to be a possibility. These visas will be granted to any asylum seeker who came to Australia without a visa, regardless of how long ago that was. If they didn't already have a permanent protection visa at the time of the last federal election, these 2 visas are now their only option. And this has led to some absurd results, such as the case of 2 brothers, one of whom happened to be granted his protection visa before the election for no particular reason, and another one who wasn't. Both these brothers have wives and children back home. Now one is able to bring them to Australia permanently, and the other could be indefinitely separated from them. The negative impacts on mental health of temporary protection visas have been written about at length, and we can go on about them forever, but that doesn't help our clients right now. And what our clients right now need is information about what their legal options are and what they can do. For so long, there's been a lot tight control on information by the Department of Immigration, so now asylum seekers are desperate for any information that they can get. To respond to this need, since the end of 2013, RACS has run a series of education and outreach projects so that we can try to get information out there to as many people as possible and keep people up to date as the changes happen, rather than people having to rely on rumours. We've organised large community information sessions, usually somewhere in Western Sydney, where we explain what these visas mean in very practical terms. Over the last 18 months, we've held about 150 sessions, both for asylum seekers and also for community organisations. And to give you an idea of the demand, these sessions are often attended by over 100 asylum seekers each time, and we've held them in most of the major language groups of all the clients. Last year, we also started regular outreach services at Auburn and Parramatta in partnership with local asylum seeker welfare services. So one day a week, a lawyer from RACS goes to Auburn and Parramatta, armed with a talented team of volunteers, to run a drop-in service for asylum seekers who want information. And in the last 3 months since temporary protection visas became law, we've seen that the number of people turning up for information at these services has jumped from around 6 people per day to sometimes over 100. So it's an illustration of the desperation of people out there for information. But to the credit of RAC staff, instead of panicking at these enormous numbers, they've shown an incredible ability to remain calm and think of innovative ways to ensure that every person who turns up there can get some kind of assistance. And this flexibility is key in this type of legal environment that changes week to week. This type of work can be incredibly tough, though, because often the information and news we're giving people is very, very disappointing. I've stood in front of a room full of around 200 Hazara men at their local mosque as they sat cross-legged on the floor, and to tell them that they'll never see their wives and children again is quite simply heartbreaking. But we managed to remember why we're doing this, and that's because we believe that asylum seekers have a right to know what the law says, what their situation is, so that they can make informed decisions about the future of their lives. The second change to the law that has really affected our clients at the moment is the creation of a new fast-track process for assessing the protection claims of asylum seekers who arrived by boat between 13 August 2012 and 31st of December 2014 or 2013. The process is called fast-track assessment, and in a lot of ways it's like the ordinary protection visa assessment process. A person completes a form, goes to an interview with the Department of Immigration, and then immigration makes a decision. But the fast part of the process is that if the decision is negative, the person does not have the right to appeal the decision to the Refugee Review Tribunal. And instead, in some cases, their matter would be automatically referred to another type of review body called the Immigration Assessment Authority, which will conduct a review just on the papers. The person would not be invited to attend an interview, and except in exceptional circumstances, the IAA is unable to consider new evidence that a person might provide unless there's a good reason. This restricted right of review means that there's a greater chance that people who need protection are going to miss out and could end up being returned to situations where they would face persecution. We know from previous years that the rate of overturn of negative immigration decisions by the RRT is significant. Over the last few years, it's been, on average, at least over 60% for people who arrived by boat. And on top of this, something that I'm not talking about in detail are the changes to the definition of a refugee, which have also happened in recent months. And these changes mean that it's much more difficult for a person to even be recognised as a refugee. So all of this makes it particularly astounding that the government is not providing free legal services to the vast majority of asylum seekers as they previously did. Around 80% of asylum seekers are going to have to go through this process alone without any independent immigration advice or even without any assistance from interpreters except at the interview. One small consolation is that the Department of Immigration is providing free legal services to vulnerable persons or people who are assessed as vulnerable by the Department of Immigration, and we expect that to be possibly up to 20% of asylum seekers. But for the remaining 80%, they're going to have to go through this process alone. And in New South Wales, RACS is really the only legal service that has the capacity to provide any practical legal assistance to asylum seekers in this group. Thankfully, last year, our principal solicitor had the foresight to predict that this situation might arise, and she started preparing a project to help people write statements about their their situation in their home country and why they can't go back. Statements that could one day in the future be used as part of their protection visa application. These statements are a critical part of the protection visa application process because it establishes why a person needs Australia's protection. So right now, even though this fast-track process is only just beginning, RACS has already managed to help around 300 people complete statements about their case. The way that we managed to make this work was by harnessing the goodwill and talent of very large numbers of volunteer lawyers and interpreters. And following this success, we were able to employ 2 full-time staff to run the clinic with the support of a generous institution. And that's enabled us to be able to expand the service to about 3 times what it previously was. The third and final development I'll talk about is the release of children from detention on Christmas Island. And of all the things I've mentioned, it's perhaps the most perverse example of how asylum seekers can be used as pawns in the political process. In return for the crossbench senators passing this legislation about temporary protection visas and the fast-track process, the federal government agreed to release all children from detention on Christmas Island. Away from the political firestorm about this deal, the RACS lawyers celebrated with mixed emotions because for us, it also marked the end of a year's worth of very hard work to try to get these children released from detention. One of our lawyers had started working with the children in January last year. And with limited legal options available, RACS lawyers lodged complaints to the UN Human Rights Council, arguing that Australia would be breaching their human rights by transferring them to detention on Nauru. At the same time, we let the Department of Immigration know that these children have lawyers in Australia and we want them to be released from detention. And in the short term, this stopped them from being transferred to Nauru. And this in itself was a huge success. But for the time being, the boys remained in detention, which was having serious consequences on their mental and physical health. But RACS kept in regular contact with the boys throughout this time, but we were just a voice at the end of a phone line, thousands of kilometres away, and our lawyers felt that that distance was creating problems with the trust and barriers to the relationship. So through the generous support of a private donor, in September last year, 3 lawyers were able to travel to Christmas Island and meet with them face-to-face for the first time. For these children, RACS, and in particular one lawyer, was the only constant feature in their lives. We built trust by providing frank and honest advice to these clients about their situation, rather than sugarcoating things or giving them false hopes. During the Australian Human Rights Commission's inquiry into children in detention, RACS was able to be a unique voice because we were in the unique position of being able to provide the perspective of the clients at a time when they themselves were unable to speak out. Now, these children are living in the Australian community, some with friends, some with family members, and some trying to make their way alone. And although they still carry many scars from the lengthy detention and the impacts that we all know that has on children, we've seen that they're now dramatically different, some of them, from how they were in detention. Through the support of many volunteers and private funding, RACS is now able to offer representation to all of these unaccompanied minors on their immigration matters. These children will be part of the fast-track assessment process, and if successful in being recognised as refugees, they too will be granted temporary protection visas. And so this will entail many challenges for them, but it's a world away from where they could have been without RACS's assistance at that crucial time when they were facing transfer offshore. So where to now? In the wake of these legal changes, at RACS we often find ourselves looking forward to the next legal changes. Because that's our only hope for potentially having some of these really negative impacts reversed for our clients. With every new change, we hope that RACS can be there to help explain it to people, to help them understand their legal situation and their rights, and help them to deal with the consequences. I'd like to thank everyone here tonight and who not here tonight who've shown their generous support and leadership on this issue and for the work of RACS. Most of our legal services are now funded through private sources, and we would not be able to do the work that we've done without everyone's support. Thank you.
Hello everyone. I too would like to acknowledge the traditional owners of the land on which we gather and pay my respects to their elders past and present, and respects to any Aboriginal or Torres Strait Islander people here with us tonight. I also want to acknowledge, as I described, one of the ways in which we have responded to some asylum seeker need as a law firm through our pro bono practice, that we are only one of many firms that are doing that. In fact, many members of the legal profession that are acting in ways to support asylum seekers. That I know many friends of RACS who have been providing support through secondments, through different legal engagement along the way. We originally got involved with refugee matters through our pro bono practice in a way that was more directly animated, I guess, by our lawyers than any other aspects of our pro bono practice, and that was after the Tampa events, when a number of lawyers came in to the office over the weekends determined to do something about that. What they did obviously wasn't effective, and I'm sure there were lawyers around Australia doing the same thing. But that was really the impetus to where we started. And originally the work that we then got involved with was confined mostly to looking at the review options of people who had been declined visas by the Refugee Review Tribunal, partly because we had a number of lawyers who were already engaged in administrative law, and that was the area we were looking at, and also because it didn't require us to get migration licences, which can be quite costly. So for a number of years that was the focus of what we did here at Gilbert and Tobin, and again we work very closely with RACS and another number of community organisations supporting asylum seekers. We have also noticed over the past years the drop-off in that area of work because of the lack of processing of people's claims. And we were also looking at the areas of need and where they were growing, particularly with the funding cuts for organisations that are supporting asylum seekers actually making their applications. So at that stage, we worked with RACS and with the Asylum Seekers Centre to provide support for a new roster that RACS was staffing at the Asylum Seekers Centre to asylum seekers actually putting in their applications for a protection visa. So this did require us to bite the bullet and get some migration licences, which we did as volunteers through RACS, and the process was much smoother than we anticipated, although a few of our photos were rejected because apparently our firm had touched them up so that we look good for our websites, but it was no good for the AFP. So we had to go out and get very, very plain and bland-looking photos down on the corner there and send them in before we were approved for our licences and could actually start work. But we started on the roster about 6 months ago, and the process that we undertake is that after RACS have screened Asylum Seekers Centre clients who are in most need of assistance, we have 2 lawyers that attend the roster each Monday for 2 to 3 hours to assist the clients through their visa application. So with most of them, that involves taking a statement and developing that statement. It goes beyond that initial assessment, so the work will be brought back into the firm. Sometimes it's easier for the clients if we go back out to the Asylum Seekers Centre on a Monday and do it in a continuous way, but we're flexible around that. With a number of the clients, we've also then attended the interview at the department. Because it's only 6 months old, there hasn't been too many, but we have done a few. We've also taken on some matters that have come to us not through that process, but with RACS's support, had referrals made to us so that we can still do it under our migration licences as RACS volunteers to assist some other people that have been referred in other manners. And so we have been to a couple of RRT interviews through this as well. So that has let the lawyers involved in the programs have quite a broad experience. And it's a very different experience from what we're undertaking before, because sometimes the lack of representation at the RRT or the representation that was perhaps inadequate by various migration agents, none of which I'm sure are in the room tonight, was very frustrating when you were trying to do an RIT application, especially when your client's singing, but that's not my story. So it does give us the opportunity to try as best we can to include the client's complete story in what we're doing. I think we've probably seen about 30 or 40 clients through the roster, which I know in the overall scheme of things is not a huge number of clients, but we're hoping that we can make a difference to those 30 or 40, and some of those are members of a family, so it's a little bit more extended. And of course, the people we are dealing with through that roster are people who have come with a valid visa of some sort, so are not necessarily affected by a lot of what Gemma was talking about. However, of concern with what Gemma was talking about, and I'm sure a number of you have experienced this, and I don't need to say it, but perhaps just to emphasise the concern even with the fast-tracking process and the people who are identified as most vulnerable by the department as needing assistance, I think can be a very tricky process because a number of people are unable to articulate their claim with any sort of persuasiveness or any detail because of the trauma that they've experienced until they've developed some sort of relationship, and I'm not sure that the department's going to be in a position to capture all of those people effectively and provide them with the referral to the support that they need. Another area in which we have also recently been acting, in addition to some ongoing judicial review, we do have a few of those still dripping in, is in relation to people who are temporarily in Australia from overseas processing centres for medical treatment and trying to assist them in making applications for the ability to stay here to get the appropriate level of treatment that they want and need, and to do that in circumstances that will mean the treatment is effective, and often that means it's outside of a detention centre, because when a lot of your trauma is associated with the detention, you're never going to get better. And so we are acting for a few clients in relation to those sorts of matters as well. I think that the way that a number of the legal profession have come together to work in a collaborative manner should also be acknowledged and commended. There is no, in my experience, jockeying for prime position. It's all about supporting people in the best way we can. There's an enormous amount of sharing of resources, ensuring that clients have the best protection they can by the best means. We've only met David in person tonight, but it didn't mean we weren't annoying him over the weekend through Amy Rogers, who's trying to hide up there. So he couldn't have a peaceful weekend in relation to issues that he had expertise in that we wanted to garner in relation to clients. And I'm sure many of you are engaged in that, but it's something that hopefully will continue. And sometimes you actually need some funding to do that most effectively. And there's been many firms generous in supporting that sort of approach as well. So thank you.
Well, thank you both. So I'm a barrister. I practice primarily in public law. So sometimes I work for the government, these days more often against. I think that I suppose my clients are probably of varying degrees of sympathy. So there was a time last year when in the High Court at different times I was working for bikies, terrorists, tax avoiders, and also refugees. So all the people that the government loves to hate. But of those, it's probably the work I do for refugees that's closest to my heart. What I wanted to talk about this evening was just a few comments or a few thoughts that I've had on strategic elements of litigation in respect of refugees. And I'm not by any means an expert. And in fact, one of the things at the bar you're encouraged to do is to really see cases as self-contained and in and of themselves. So you're not encouraged to think, well, if we win or lose this case, what is that going to mean in terms of public policy? What's that going to mean in terms of politics? Ethically, you're encouraged to work for a particular client for the interests of that client in the particular circumstances of the case. So it's actually people like you here tonight who work in policy, who may work in politics or social change, who are probably more effective at being able to drive change in this area. But for what it's worth, here are some comments. So I wanted to talk about three topics tonight, so far as I've got time. One is Operation Sovereign Borders. Another one is offshore processing. And a third is onshore processing. So it's probably going to sound a bit like an episode of Q&A. Operation Sovereign Borders, it was about a year ago that I got a call on a Monday morning from a Sydney solicitor called George Newhouse, who some of you might have had some dealings with. George ran the Cornelia Rao litigation about a decade ago, and he does kind of public interest law. I think he called himself a special counsel, which I think means that you can do whatever you like. A special counsel at Shine Lawyers. And George had just had a call, I think, from Ian Rintoul, who is a human rights advocate in Australia. And Ian had a call, I understand, from someone who was on an asylum seeker vessel, who just said, I'm on an asylum seeker vessel somewhere in the Indian Ocean. Our vessel has broken down, and we think we're about to, or we already have been boarded by Australian customs officials. So what followed from that was the High Court case that became CPCF, decided earlier this year, heard last year. In the meantime, this group of many asylum seekers was kept on the high seas. They didn't know where. We didn't know where. For a few weeks before eventually the government brought them to Australia and then, without telling us, took them to Nauru at 3 a.m. One morning. There's just a few comments that arose out of that. One is people talk about, and it's obviously the common phrase now, it's an on-water matter. I'm not going to comment on it in the absence of information. I think people mostly think about that in terms of distorting or depriving the public debate of information, but it has a very real effect on the ability to properly, for the courts to properly supervise what is happening in respect of Australia's asylum seeker policy. It was extremely, CPCF would never have come about but for the fortuitous event that there was someone on that vessel who had a mobile phone or some satellite phone that had reception, that had a working battery, that was able to communicate with someone in Australia, that had a connection to George Newhouse, to Ron Merkel and to some other Sydney barristers. And so we were able to then file a High Court challenge that day, by 3 o'clock that afternoon. The vast majority of turnbacks do not have that luck, do not have the opportunity to properly test whether what the government is doing is in accordance with the law. The second, so that's the first point about the lack of information is the inability to find a plaintiff who can, in the heat of the moment, and a lot of the current asylum seeker policy does happen in the heat of the moment. You've only got a few hours when you can properly intercept what's happening. So the ability to find a proper plaintiff. The second thing is when we got this call from the person on the vessel, we didn't know anything about where they were, what involvement the government had in intercepting that vessel, what the government was doing, what powers the government was trying to exercise. And the first thing that you do when you turn up to court is you can't turn up and say, I'm someone who's on the Indian Ocean. You need to be able to tell the court, I'm on the Indian Ocean. The government has in a vessel exercising powers under the Maritime, purportedly exercising powers under the Maritime Powers Act, boarded my vessel, detained me, and is now taking me to a place. And for these 4 reasons, having regard to what the government has done, it is unlawful. But you cannot get to that stage unless you have information about the way the policy works. And at the time, this was last year when before CPCF, we didn't know any of the details of the government's policy. Scott Morrison was going on Ray Hadley every Monday and just saying, it's an on-water matter, I'm not going to tell you about it. And he was having his weekly briefings and saying, 0 boats, everything else on-water matter, not going to tell you about it. And so we had great difficulties in being able to formulate a claim that could properly come before a court and sound in relief. So just in terms of the absence of information, to the extent that people here have any sway, and the absence of information is not just relevant to policy, it's also relevant to litigation. The next point I wanted to talk about was what is a common theme, perhaps for people who've been involved in litigation in respect of refugees, which is that you start litigating against the government, and just when you've got a good point, the government changes the facts or changes the law, one or the other. That happens very often in on ashore matters. In the case of CPCF, we litigated against the government for 3 weeks, and then they changed. Well, first, while we were litigating against them, they changed the law, but only prospectively. They went through our statement of claim, and every error that we had asserted, they passed an act that said that error is no longer an error. When you said you cannot take, the power to take has to be a power to take to a country and can't be to a vessel, they changed the law and they said you can take anyone to a vessel. When we said you can't change halfway through while you're on the water what destination you're taking someone to, they changed the law and said the minister can, in his discretion, change the location that someone is being taken to. So that only applied prospectively, so it didn't affect us. What did affect us was when the government changes the facts. And I know it's happened to a number of people who've been challenging detention in Australia. And just when you get a good case that can properly test the limits of power, the government releases the person from detention and your case goes. So you have to start again from the outset. What we had was on water for 3 weeks, the government not telling us where they were taking these people. We presumed they were taking them either to Sri Lanka or India. But then, just when Justice Hayne is starting to get upset with the Commonwealth brings them to Australia, to Christmas Island, then to Western Australia. And effectively, so far as we were seeking prospective relief, which was injunctive relief, saying you cannot take these people to the place you're intending to take them to. The government never told us where they were taking them. You can't take these people to an undisclosed place. We were no longer able to get that relief. So those who are lawyers will be familiar with the concept of mootness. It's to moot a matter. 2 consequences of that. One, we had to change our claim to a claim in tort for false imprisonment. Because that is not a claim that could be mooted. It was a claim about the unlawful conduct that had occurred on the vessel. Now, legally, that gives us as strong a claim, but politically, it allows the government to say, look at these asylum seekers. Their business model now is to come to Australia, and as soon as we're taking them back, to try and get money from the government, to try and take money from the taxpayers. And at the level of the merits, the justice of the situation, which does matter before the court, you're no longer coming and saying, I'm seeking an injunction to stop me being taken back to a place where I fear torture. You're instead going to the High Court and using effectively the same administrative arguments, but saying, I'm coming to the High Court to seek money. And it's just not as strong an argument. In the United States, they have a doctrine called permanently arising yet evading review, which is an idea of standing in litigation, which says that if you're someone, say in our CPCF position, the people who their matter was mooted so far as we were seeking injunctive relief, you can still have standing to seek injunctive relief in respect of future possible plaintiffs, so people who will be on the seas in the future, because it's a case where the issue is permanently arising. There are always turnbacks, but because of the nature of the situation, because it's on sea, limited access to courts, it evades review. In Australia, we don't have that doctrine, and in terms of people who are public interest lawyers here, I think that would be a good thing to work for, a good thing to work towards. A couple of other comments on Operation Sovereign Borders. Government changed the law partway through. That's largely a consequence of the fact that we don't have a constitutional Bill of Rights in Australia. In America, or in countries with a constitutional Bill of Rights, when government breaks the law, it can't just fix it, often, if it's a constitutional defect. In Australia, we largely have statutory, because our public law is largely statutory, you can just overcome it by changing the law. Just future challenges to Operation Sovereign Borders. So obviously there's been a lot of talk in the media about payments to people smugglers this week. There is likely to be a challenge to that if there can be a proper plaintiff, and the argument would be the government needs statutory authority to spend money. There is no statute that authorises either spending money giving money to people smugglers, or alternatively, if there is on its face statutory authority for that, it's ousted by the criminal code, which prohibits individuals from effectively being complicit in people trafficking to another country. So watch this space on that. I should say there are also CPCF. We lost 4-3, but the High Court dropped a few little bombs in there for the government. So if we can find another plaintiff, it can and will be on again. So offshore processing. The team that challenged Operation Sovereign Borders last year has largely got together again to challenge detention in Manus and Nauru. So you might have seen the cases filed a few weeks ago. The Human Rights Law Centre in Melbourne, they went on the 7:30 report a few weeks ago to talk about it. So Human Rights Law Centre in Melbourne, and also Stack's Lawyers in Sydney. The basis of the challenge is the government is funding and also contracting to procure detention on Manus or Nauru. And the High Court has said a few years ago in a landmark case called Williams that the government needs statutory authority if it's going to spend money or if it's going to enter a contract. And we say that there's either no statutory authority for it, or alternatively, if there is statutory authority, it's not clearly expressed. And before the government can lawfully fund or procure detention, it needs to have clear, basically unmistakable language before you can do that. We're also running some heads of power argument. Effectively, the government cannot, and Chapter 3 arguments, the argument being the government cannot procure detention unless there is a court order authorising that detention. One thing, a few things I'd say about these proceedings. One is, I think if they're successful, it will be an extremely important plank in the development of human rights jurisprudence in Australia, because the critical thing the government has done here is to distance, in Manus and Nauru, is to distance itself from the detention. Habeas corpus focuses on the jailer, the person who has custody of the plaintiff. And since time immemorial, people have been able to obtain release from unlawful detention by issuing a writ to the jailer. what the government has done is it has made itself not the jailer. It has instead interposed between itself and the jailer a series of private entities, like a multinational corporation trying to avoid tax. So between the Commonwealth and the actual people on Manus and Nauru, you have Transfield Services, then Wilson Security, who is subcontracted by Transfield, and then you have an ambiguous interrelationship between Wilson Security and the government of Papua New Guinea and the government of Nauru. What that does is it obfuscates accountability. It makes it extremely difficult to work out who to sue, who is actually causing the problems here. One very effective thing the government has done is, because it's offshore, those of you who know your choice of law principles know that normally torts that are, the law that governs a tort is the law of the place where the tort happens. So when people talk about the conditions in detention on Manus and Nauru being cruel, inhuman and degrading, or constituting torture, and therefore a tort, whether it's battery or assault or some kind of unlawful imprisonment, the law that governs those torts is actually the law of Papua New Guinea and the law of Nauru, not the law of Australia. So by taking it offshore, the government changes the legal structure that regulates it. But then also, courts, an Australian court is not going to want to apply the law of Papua New Guinea or the law of Nauru. So you basically can't get into an Australian court, and you're left with the systems in Nauru, and obviously that extremely effective judicial system in Papua New Guinea. Now, that's why you need to come back to public law principles and why we've got a complicated challenge to payments and contracting. The second reason why this would be an extremely important plank in human rights jurisprudence is this is a case where we say the government, although it doesn't have actual control of the detention, it has what international lawyers would call effective control. The government has procured this detention by means of contracts with Transfield and agreements with Papua New Guinea and Nauru, and it controls extremely fine details of that, to the level where the Commonwealth can actually fire anyone who Transfield employs in Manus and Nauru. One thing I should say, there was some talk a couple of weeks. One thing I've come through in these proceedings is the actual contract between the Commonwealth and Transfield. There was some talk a couple of weeks ago about Sarah Hanson-Young being covertly surveilled, and there was a question as to whether that had actually happened. My understanding was the government said, or that Transfield said that hadn't happened in the end, or at least they didn't admit it. Under the contract between the Commonwealth and Transfield, Transfield is required to develop and implement a system to identify all people on the site, and is to discreetly monitor the movement and location of everyone who is on Manus and Nauru. So that my reading of the contract was that actually they were contractually required by the Commonwealth to discreetly monitor Sarah Hanson-Young and presumably everyone else who is there. Now, the one point I want to make at a strategic level about the offshore processing challenge is I'm briefed to challenge offshore processing. I'm not briefed to think about what will happen next. I do, and I worry that when you have these one-off pieces of litigation, what is the effect going to be? If we're successful, the government says, okay, well, one of two things happen. Either they just pull out and say, okay, well, we won't fund this offshore detention. We'll leave it to the coffers of Papua New Guinea and Nauru. Is that a good outcome for the people who were there? Probably not. On the other hand, the government says, well, the problem is statutory, so we'll just pass a statute that makes it even abundantly clear that we can do this. And also, while we're there, we'll throw in a few other things that the government likes to throw in when they draft laws, refugee-related laws these days. So I think that there's a real role in this space for people who can think strategically about refugee litigation and can think about what happens next, and also about how litigation should only be one element of a much broader strategy for social change. How am I going on time, Francis? No? Okay. Francis, I've got to be quite. I'll talk very briefly about. I'll skip over indefinite detention. Talk very briefly about grassroots migration litigation in Australia. So just the run-of-the-mill cases, you get challenges to RRT. Those of you who work in this space will know that the RRT relies heavily on what are called DFAT country assessments, and also they now have to have regard to an internal policy document called PAM3. For those of you who can work in policy, those documents are relied on by the tribunal, but they are not public. There is no repository of DFAT country assessments, which the tribunal relies on to typically to say that refugees aren't persecuted back in their country. What I would encourage people to do is, there's no reason why those shouldn't be public. So lobby the government for those documents to be public, because it will substantially facilitate proper review of the decisions. And then just on fast-track processing, I think the view was that was a bad idea. Just from the perspective of litigation, there's actually a chance it might increase the prospects of judicial review, because instead of having tribunal members making the real decisions who you hope are reasonably competent, you're instead having departmental officials making critical decisions. And I suspect there's going to be some real opportunity for, they're much more likely not to afford procedural fairness and critical elements of the process than the tribunal will. So thank you very much, and I look forward to your questions.
Well, thank you very much to all three of our speakers for your fascinating talks, and we now have some time for questions from the audience. We have a couple of roving mics, so if you could just raise your hand if you have a question, and we might take, say, 2 or 3 questions at a time and then hand over to our panel members to discuss the issues. So, yes, we could have...
Thank you. I had a question just about the free legal assistance for vulnerable applicants. I run a legal project at STARTS, the New South Wales Service for the Treatment and Rehabilitation of Torture and Trauma Survivors. Almost all of our clients would have some form of complex post-traumatic stress disorder as a result of their trauma experiences. However, I've found it really difficult to get any information from the department about this free legal assistance or PAYS scheme. What I have been told is that we cannot apply on behalf of our clients for this scheme. The clients can't apply. The department decides who is eligible. How they do that without any up-to-date information about a client's mental health condition, I don't know. But most disturbingly, one of the factors that they take into account is what's in the interest of the government. Now, I would have thought the interest of the government would be diametrically opposed to the interests of the client in this particular situation. So I'm just wondering if you've got any suggestions as to how we could link our clients to this badly needed free legal assistance.
Thank you. There was another question on this side here.
It's a question for David. I might preface my question by saying that it might be slightly naive, but I'll give it a go anyway. You were mentioning that there were 1 or 2 options that would happen, that the government would either introduce a statute making it tighter or then just hand over to Papua New Guinea. But I'm just wondering if there's another option about Australia fulfilling its international treaty obligations.
And, all right, well, just take those two questions. If you could put your lapel mics on, actually, that would mean that we can capture this on the recording. So the first question was in relation to free legal assistance, and the second was in relation to running arguments relating to our international legal obligations.
So to respond to the first question, this is a very new area at the moment, and it's just something that we're seeing emerging day by day at the moment. So it's difficult to give any sort of concrete information right now, but it is something that people in the sector are concerned about, and we're watching very closely. And perhaps we would, it's something that the sector can look into about whether there are what sort of accountability measures there could be within policy and law, and whether there could be options for review if the sorts of assessments are not considered to be appropriate. But at the moment, it's a bit difficult for us to say.
So I think the question was if if the High Court strikes down elements of the offshore processing regime, will Tony Abbott and Peter Dutton implement a policy that conforms to Australia's human rights obligations? Look, I suspect that the government, if the High Court does strike down some element of the policy, the government is going to feel politically that it cannot completely extricate itself from Papua New Guinea and Nauru. It may try to, but it will feel that its agreements with Papua New Guinea and Nauru require it to spend money, because otherwise Papua New Guinea and Nauru wouldn't have allowed all these refugees onto their shore. And having spent money, the government is going to want to make sure that it's actually going to the purposes that the government wants to spend it on. So it's politically going to have to stay involved in some way. How will it stay involved? There's nothing in our challenge that says that the government has to stay involved in a way that's consistent with human rights obligations. That's because there's no constitutional prohibition on the government of Australia contravening its human rights obligations. You have to come at it indirectly.
Thank you. Any other questions?
Firstly, a sincere thanks to Renata for your introduction. It was very powerful. And thank you to the panellists. I'm not a lawyer, I'm a high school teacher. And I'd like to read a short quote from Klaus Newman's Across the Seas, Australia's Response to Refugees, a History. And in his conclusion at the end of this work, he has these words: "This book has tried to suggest that there is nothing self-evident or natural about Australia's current response to asylum seekers and refugees. I hope to have encouraged you, my reader, to imagine alternative futures which take into account Australia's capacity to assist people in need of a new home, its responsibility as a regional power, its legal obligations as a member of the international community, and most importantly, the precarious circumstances of the men, women and children who are seeking Australia's protection." I guess my question to each of the panellists is, what would you hope to see in the future in terms of Australia taking a leadership role within this region? If we're working with Nauru, if we're working with Manus, in inverted commas, if we're working now with Cambodia, in inverted commas, what would you like to see the Australian government do in the future to take a leadership role in the region?
Thank you. We'll take one further question in this round. There is one. This side.
Hi, a slightly more procedural question. I work at Red Cross, and so to date, I see lots of clients who are RRT rejected and concerned about limitations to what they can do. I'm pretty distressed about, but we don't know what this IAA process is going to look like, and I'm interested to hear how both RACs and, in fact, all of you are thinking of how we're going to respond to people who are rejected at the IAA level.
Thank you. So we had one question which was asking what would leadership look like from Australian leaders on this issue, and the second about the IIA process for rejected asylum seekers.
All right, I'll go first. In relation to the leadership role that Australia could potentially play, I guess, the immediate concerns that RACS has is the treatment of asylum seekers and refugees who are here in Australia. And one of the most pressing concerns is temporary protection visas and the sorts of rights and entitlements and status that people have when they are recognised as refugees here in Australia. It's very difficult for Australia to have an impact, or much of an impact, on the international context. And the international context is extremely complex, but something that we do have control over is how we treat people who do come within our territory. So that's one thing, to set an example by providing people with permanent protection and particularly options for family reunion once they are recognised as refugees. In terms of the broader region, I think Australia could also set a very strong example by acknowledging and respecting the international human rights standards and standards under the Refugee Convention. It's something that we've seen has been detracted from, I guess, stepped away from in recent years. And at RACS, I think we would hope for, in the future, strong statements and support from the government acknowledging our international legal obligations. Did anyone else want to comment on that one?
Just briefly, I think, unfortunately, we do take a leadership role at the moment, and it's not a good one. And it's not just in our region. It seems that it's, permeating through to attitudes in Europe or strategies and so on in Europe. And I think the other thing that the government is doing is arranging reports, inquiries and so on, and then using the parts of those reports that suit them to pursue objectives that they have, rather than looking at them in an objective way that, some of the reports people talk about that there are carrots and sticks, and it seems there's all stick and no carrot, even when these reports or inquiries are conducted by people of their own choosing.
In relation to the question about clients who are rejected, say after the RRT or by the new IAA, RACS works with these clients, and we can see that this period of time for clients is usually extremely distressing, because although these clients have had an opportunity to present their case on 2 occasions, the process of assessment is far from perfect, and there are a lot of reasons why a person might feel and might not have had a fair hearing throughout that process. So for people who are rejected by the RRT, there is currently the option of seeking judicial review if there were legal errors in the way that review was conducted. And we expect that the same sorts of opportunities might be available to people who are either rejected by the Department of Immigration or the IAA in the future. So there could potentially be options for judicial review, as Dave suggested.
How do we send people to find assistance because I know that's an issue that we currently have. There's a lack of lawyers to sort of assist people with their JR claims.
Yeah. So at RACS, any person at any stage of the process of applying for protection can contact us for advice, and we will give them an initial advice about their options.
We'll also take direct referrals in that area and have always done, including with the Red Cross, but I think there's staff changes and so on that affect that. And we're also in contact with other firms. And as I said before, it's quite a collaborative process where we can pass people on. And the concerning issue is, though, what you raise. We've been doing this sort of work for a long time, and the success rate in challenging our RRT decisions is quite high. Having said that, we screen, but it's still significant. And what you're concerned about then is the number of people that aren't even getting the opportunity to challenge those decisions and the dreadful impact that can have. And the other thing is, if it's not just contacting us, certainly Justice Connect throughout New South Wales and Victoria can help place these matters, and there's Q Pilch in Queensland. But if I can talk to you later about putting together, I guess, a list of referral agencies that might be able to help in addition to the stretched resources at RACS.
From my perspective, the Commonwealth cannot take away judicial review of administrative decisions. So no matter how far they go, that will always be available. They can limit the kind of grounds you can rely on in substance. In terms of the practicalities of it, at the bar, there are probably two ways that work comes in from asylum seekers. Some have money and they will pay, and they will almost always be able to attract a barrister. That is not many, certainly not most people who've had adverse RRT decisions. There are a number of barristers, particularly junior barristers, who do work on spec for asylum seekers. There's a law firm in Sydney, international law firm at the Sydney office, Fragaman, who their practice is they will write to members of the junior bar who practice in public law and say, will you review the papers, send us any grounds of review that you have, and if we're unsuccessful, you will not be paid. If we're successful, you will be paid up a reasonable amount of whatever costs we can recover from the Commonwealth. And Fragaman is extremely successful in obtaining juniors to do that. The reason why they're successful is there are people who believe in it. It's good experience for junior barristers because you're in court on your feet arguing important, interesting public law issues, and so long as you only advise to go ahead with cases that are reasonably arguable, you've got a fair chance of getting a recovery through a costs order. So there are people who do it. You've just got to just literally approach the junior bar people who say they do public law on their CVs.
Thank you. We'll take another round of questions.
In the press just over the last couple of days, there's been reference to the rules for FOI requests being amended adversely for people needing their documents for the submission for the fast-track process. Does the panel have any substance or insight into those rumours or those press articles?
Rax was quoted in one of those articles, so we do know a bit about it. The freedom of information process is something that we help people with on a daily basis, sometimes up to 20 people a day. And what people are seeking to do is that they're being or will soon be invited to apply for a temporary protection visa, but because they've been here for perhaps 2.5 or 3 years, they might already have done several interviews with the Department of Immigration in the past. And the Department of Immigration holds many documents and records of those sorts of interviews. So as lawyers, we advise people to get copies of those documents, as they are entitled to do under Freedom of Information laws. So any person is entitled to seek access to copies of documents that contain personal information from the Department of Immigration. And as lawyers, those documents are essential before we can provide any legal advice to a person or assistance in their application. So there are extremely large numbers of people who are seeking access to these documents. We understand that the department's resources are completely overwhelmed by this, and so in response they're asking people they're returning the person's request for their documents to them, not refusing the request, but simply returning it to them and asking them to wait. And in practice, that seems to be denying these people the right to access their documents, which is their legal right. Just delaying it is not enough, and it's having, it has serious effects on people's cases because it means that it's going to delay their case a lot longer. So we're very concerned about it, and I know there are numerous people in the sector looking into the legality of this process.
I'll say a couple of things on that. One is once a case gets into court, you have available compulsory court processes, notices to produce and subpoenas, and the government could not probably constitutionally could not take those away. The critical role that the Freedom of Information Act plays, and putting on what Gemma said, is to get to court, you need to have a pleading that someone has signed off on saying there are reasonable prospects of success in this argument. And typically, to identify that there are reasonable prospects of success, you need to look at a large number of documents that explain what has happened to this person, what role the government has had in their detention or their adverse refugee decisions and so on. And very often, people do not have those documents, and you need to rely on the Freedom of Information Act to get them. So where that comes in is actually not getting you in the court in the first place. That would then entitle you to use compulsory process to obtain the other documents that the government has relied on.
I think just from a more general point of view, what it demonstrates is that in this entire process, access to legal services is vital, but there also gets distracted into issues like this, and we can't address the fundamental protection issues because now we've got arguments about freedom of information, and now we're addressing this, that and the other, and it's all part of the government's knee-jerk reaction, and there is no overall strategy that's clear, and they're responsive, often in very negative ways, but it also has this flow-on effect that legal resources that are already limited then get distracted into other avenues.
Any further questions from the floor?
I belong to an organisation called Supporting Asylum Seekers Sydney. We go out to Villawood and some of the other detention centres when we can. We see about 100 people out there, asylum seekers, and what we're finding is that we've actually got very little legal help. I know that you're helping out with the Nauru and Manus Island, trying to keep them in Australia. But as far as we're sort of getting very nervous about this fast-tracking situation where, I've seen a few coming from outside where they've got a month to respond, and we're not a legal group at all, but they're asking us to help them legally, which is frightening. And we're just wondering, where can we go for help? I know RACs don't do inside Villawood at this point. I could be wrong there, but we haven't had that yet, and we're finding it very difficult to get lawyers to come into the detention centres.
Sure. Thank you. RACS provides a telephone advice service to anyone in detention, so at any time they can call to get advice over the phone. In terms of practical assistance with their applications, it does become a matter of resources, and we are at very stretched capacity, but we have provided assistance through our volunteer lawyers to people in detention for assistance, and subject to our capacity, we would certainly consider doing more. So we're always happy to talk with people who understand what the need is like in detention and to review cases on a case-by-case basis.
We too they were just some of the projects we've been involved in, and we've regularly worked with clients who are in detention. It would depend on the nature of their claim. Certainly the judicial review clients, we can take as many as we're possible to take, which could be quite a few at this time. We may be more limited if they're clients that are actually wanting to make asylum applications simply because we need to do that through RACs, as we're volunteers through RACs and our migration licences, but it does depend on the nature of the client's legal need, and we're not limited to what I said. We're currently working on, we do a whole range of stuff in addition to that, so we should talk.
But I also will say that it's a huge need, and it's something we are really concerned about because there were previously free legal services available to some asylum seekers in detention, and those services were cut last year by the federal government. So it has left an enormous hole, and we're trying to see, a lot of services are trying to see what they can do to fill the hole.
As we get to this late hour of the night, I thought it might be helpful if the panel has any thoughts on what the general public can do to either assist or complement the efforts that the legal sector is doing. And we've heard a lot about limited capacity, but people who are interested but not necessarily lawyers, what type of thing could they do to support the work that you're doing?
I know our clients want Australians to change the law. So they are constantly asking us, will the law change again in the future? So I think any advocacy that people can do in their own contexts in relation to changing temporary protection visas and allowing people to have permanent futures in Australia. In terms of direct legal services, RACS, as I said, relies to a very large extent on the support of private donations. We have a Friends of RACS program where people can pay just $10 a month to sign up and become part of the RACS team and all the work that we do. All the details of how people can support RACS in our work is available on our website.
I think more broadly, it's the obvious stuff, isn't it? It's talking to your local members. Your local member, when I talk to him, tells me I've got to come along to the local branch meeting to persuade other people. They're always in agreement with me, but nothing ever seems to get done. But the more people doing that, and just on a more practical level, I think so many people, even if they may they're not intimately informed about the issue. They have a general view that is not necessarily hostile, but can be readily persuaded by the headlines in the press. So if we have an opportunity to perhaps correct people's views on that in the way you think is appropriate, I don't think we should ever let that opportunity pass, because the false information out there just seems to grow and magnify.
I don't have much more to add beyond changing the law.
And if I may finish with one final question. We've heard about how many aspects of the legal sector have really stepped up to assist and collaborate, but we've also heard about the need for more strategic thinking and a more strategic approach on these issues in terms of the law. So could panel members share some ideas about avenues and prospects for a more strategic approach, both to litigation and to legal advocacy in this area? Just put you on the spot.
Without sounding self-satisfied, I think that it's been probably pretty good without funding. To date, there have been a number of strategies initiated by RACS, initiated by organisations, by Justice Connect, but initiated by law firms and the bar itself with pro bono practices. And, we've never been turned down by a barrister that we've approached to act in any of these matters. And there's a lot of sharing of information. The matters that David's talking about, our firm and other firms with pro bono practices, we know about them. We're talking to the lawyers that are doing the work. There's sharing of research. I think that could be enhanced, but it's all about money. It's about having funding to pay somebody to put the time into coordinating. But the other thing is, as David's talking about, you need to be responsive. You don't know when you're going to get that call from somebody on a boat in the Indian Ocean. But the fact that people are collaborating and are well networked, I think, helps enormously with that.
Building on that, look, this is by no means the most important thing, and I think I've said a few things in the address on various strategic issues, but it would be extremely useful to have a central repository of information on various key issues. One of them is, so far as there are constitutional constraints on what the government the government's detention of asylum seekers, there is probably a constraint that says you cannot detain them for a punitive purpose, so for the purpose of punishing asylum seekers. And every time that argument has been run, the government has said, no, we're not doing this for a punitive purpose. We're doing this for the purpose of ensuring there's not a flight risk while they have their claims processed, or for the purpose then of removing them from Australia. Over the last 4 or 5 years, I think there's been an increasing change in public rhetoric to saying, where the government is saying we are detaining these people to deter or to punish them for having come to Australia, or to deter other asylum seekers, in the language of the criminal law, general deterrence from coming to Australia. We might need to run an argument quite quickly, like in CPCF, that what the government is doing is for a punitive purpose, and it would be useful to have somewhere where there was a collection of statements by immigration ministers, by the Prime Minister, by Parliament, that indicates that detention, or that the Australian asylum seeker policy is now for the purpose of punishment, not for a non-punitive purpose like removal. That's by no means the most important thing. Just one thought I had.
And I think that, there have been a number of failures, but there have been a number of successes through the courts in relation to this issue, demonstrates it's not a legal answer. At the end of the day, it's a changing of public opinion and government policy, and the law can only take it so far.
Like Michelle, I think that the sector has done quite well in the face of extreme challenges and losses of funding and services. We have been able to be flexible and responsive, which is essential in this sort of environment. And collaboration is our strength. And every time that we've seen a challenge, we've looked at the way that RACS has, and with our partners and collaborators, we've looked at what resources are available in the sector, who are the people who are able to offer skills or services, where do they lie, and how can we all together best use all of those different skills, whether that's corporate law firms or community volunteers, bilingual people within asylum seeker communities themselves. There are resources out there. There are incredibly passionate people, and by working together, that not only expands our capacity dramatically, but it also brings people into this work and help people understand the sorts of issues that are going on.
Well, thank you very much. We'll need to bring our discussion now to a close, but we would very much like to thank our three speakers for sharing their thoughts about the considerable challenges that are being faced by asylum seekers and by those trying to assist them, but also the great innovation and collaboration that we're seeing amongst members of the legal profession who are trying to assist refugees and asylum seekers to access their rights. So please join me in thanking tonight's panel. We'd also very much like to thank Renata Kaldor for joining us this evening and for sharing your introductory remarks. And thank you also once again to Gilbert and Tobin for very generously hosting us, and particularly to Stephen Glass and Rebecca Shaw for assisting us in organising tonight's event. And finally, thank you very much for coming. It's very heartening to see a full room of people who are interested in discussing these issues, and we hope that you will join us in continuing to discuss them over refreshments. Thank you.